The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen, and welcome to this IT governance webinar on the first steps towards GDPR compliance. I'm Alan Calder. I'm going to be your host this afternoon. I'm the founder and chief executive of IT Governance, which is the single source of everything to do with data protection and cybersecurity, which means that we deal across a very broad range of books, tools, software, consultancy, and training for organizations seeking to secure themselves from the myriad of today's threats and to ensure that they comply with the European Union's new data protection regulation. I'm the author of a book called IT Governance, an International Guide to Data Security in ISO 27001, now in its 6th edition, which in its first edition led indirectly to the creation of this business and the growth of the business over the last 12 years to probably one of the leading organizations in GDPR and cybersecurity. We floated with a newly created parent company on the AIM market in the UK about 6 or 7 weeks ago. As I said, we primarily look at services and solutions for our clients in and around information security and data protection, but supported by business continuity and with penetration testing, incident response, PCI, and everything that goes with making sure that data is secure. You'll have noticed that you're on mute. I'll be working through these slides with you over the course of the next 45 or 50 minutes. At the end of that period, with a bit of luck, if we finish on time, we'll have about 10 minutes where we can deal with questions. And if you find that you have questions as we go through the webinar, please do use the questions box on the GoToWebinar panel on your screen. If you click into that, you can type a question in there at any point. And then when we get to the Q&A session, what I'll do is I'll start at the top. I'll pick up the first question and I'll read the question to you, and then I'll share the answer. I'll get through as many of those as I can in the time remaining, and we're aiming to be done by 4 p.m. GMT this afternoon. So today I'm going to be talking about the regulatory landscape, the territorial scope of GDPR, the key principles of the regulation, rules around breach notification and data subject rights, changes to consent, liabilities of processors in the context of relationships with controllers, the roles of the data protection officer. I'll look briefly at international transfers of data and the wide range of activities which fall within the concept of international transfers. And then finally, the role of regulators and how across the 28 member states of European Union, GDPR should deliver or should make possible a level playing field for both data subjects and for organizations operating in the European Union. It's worthwhile just backtracking slightly to talk briefly about the difference between directives and regulations, because it's the cornerstone of what's happening where GDPR is concerned. A directive is exactly that. It's a directive from the European Commission to member state governments saying that they must pass a law which puts into place a minimum set of requirements, minimum set of fines, but which allows the member states some latitude as to how they go about doing that, and of course allows them the latitude to legislate for far more than the minimum set out in the directive. And the current data protection framework across Europe is the result of exactly one such directive, the Directive of 1995, Directive 46 of the European Commission. That led to the creation of the Data Protection Acts in the UK in 1998, which until Friday will be the relevant legislation in the UK. A regulation is immediately applicable on the day it becomes effective in every member state. It doesn't depend on there being local implementing legislation, although it's entirely up to member state governments to pass implementing legislation if they think that's appropriate. And the EU GDPR, as General Data Protection Regulation suggests, is a regulation. In the United Kingdom, the government is in the process of incorporating GDPR into the new British Data Protection Bill, which is expected to clear Parliament before the end of this week, and that will place GDPR in the framework of British law, and that means that for sure GDPR will survive the proposed points at which Britain leaves the European Union. So GDPR becomes the British data protection framework both for now and in the long term. It also applies across all other 27 current members of the European Union, and the fact that some of those members haven't yet passed enabling legislation doesn't change the fact that the nature of a regulation is it applies in the member state because it's a member of the European Union, and that's what the EU founding treaties all make possible. So the model for data protection under GDPR looks a bit like this. There are data subjects. That's us. A data subject is a natural person. A natural person is a living human being. That means that deceased persons have no rights. It also means that legal entities have no rights. And a company or a legal partnership is a legal entity, not a personal entity, and therefore it doesn't have any rights under GDPR. This applies only to living natural persons. So we're data subjects, we have rights. We own our data is what GDPR says. And it says that we might share that data with a data controller because of some particular benefit or because we have to. And it sets out a framework within which the data controller has to operate. And the data controller might outsource some of the processing to a data processor. The assumption is that most controllers will process data themselves, but if it outsources it, the outsourced organization, a third-party entity, is called a data processor, and it has to operate under a contract from a data controller. Data can be moved from the country within which it's collected to another country, and it can, provided certain rules are complied with, can be processed outside the European Union, and data can be shared by a controller with third parties or collected from third parties, again, all subject to GDPR. There is nothing in GDPR which says that you can't buy mailing lists anymore. There's nothing that says you can't collect data from social media. You can do all of those things, but there are very specific requirements in place over how you go about doing it, and above all, how you ensure the data subject is aware of what's going on. And there's a relationship between the rights of data subjects and therefore the duties of data controllers. The duty, if you like, of a data controller is to respect the rights of a data subject. The job of the Information Commissioner, the supervisory authority for the United Kingdom, is to assess compliance with GDPR and, where necessary, to enforce that compliance. And every member state has its own supervisory authority. The supervisory authority is charged with doing exactly that under GDPR, and member state governments are required to provide adequate budgets to the supervisory authority for it to do what it's meant to do. Sitting above the member state supervisory authorities is what's called the European Data Protection Board, which is in the process of being formed now out of elements of what was Working Party 29 of the European Commission. That's the group of legal and privacy experts who worked for the last 5 years or so on creating this new general data protection regulation, and it comes into force as the body which exists not as a super regulator, but as the entity which is there to ensure a consistent interpretation, understanding, and application of GDPR across all member states. So it's the mechanism, if you like, by which the European Commission has set out to try and ensure that GDPR is in fact a level playing field under which all organizations trading across Europe only have to comply with one set of data protection requirements, and all data subjects who are dealing with controllers across the European Union know that their rights are exactly the same in every single member state. So, as I said, the material scope of GDPR is the personal data of data subjects, natural living persons, but it's not just random data, it's specifically personal data which is or is meant to be part of a filing system or that is being processed wholly or partly by automated means. So a pile of calling cards, of visiting cards in the corner of your desk, which has got no particular order to it. That's not a structured filing system. So that data is not subject to GDPR. The fact that somebody gives you a business card doesn't mean that you have to tell them that you have to comply with GDPR. That's all unstructured. The fact that you mean to include it in a filing system, or the point at which you take a clutter of cards and put them in a Rolodex, at that point the data becomes subject to GDPR because it's now within material scope. It's part of a filing system, or is meant to be, or is being processed by automated means. Our rights as natural persons are for the protection of our data, for the protection of the way the data is processed, and of course for the movements of our data within the European Union to be unrestricted. And I'll talk a bit more about particularly the right to freedom of movement of data. The other thing that's important to be aware of is the territorial scope of GDPR. It applies to controllers and processors that are in the European Union, irrespective of where the processing is taking place. So the fact that you're an e-commerce business based in the European Union and you're processing the data of customers from 197 other countries around the world gives to every single one of those customers the same protections as would a subject of the data of the European Union. It also applies to organizations based outside the European Union, but which are providing services into the European Union. And that's irrespective, again, of the place of residence or the nationality of the data subject. If you're an organization and you're based in Thailand and you're providing services into the European Union, you have to comply with GDPR. So it's potentially a global data protection regulation. It applies to any organization processing data if you're in the EU or if you're providing services into the EU. And it's a regulation that has teeth. It has teeth because breaches of the data protection regulation can go up to fines of 20 million euros. I stress that's up to. In other words, it doesn't apply to every single breach. It can be reduced by the extent to the negligence, by the extent to which you can prove that you were not negligent in meeting your compliance obligations. And the 20 million euros only applies to breaches in the key areas. In other words, breaches around the rights of data subjects, breaches in relation to the 6 data processing principles, and breaches in relation to transfer of data outside the European Union. There's a lower tariff of fines, which is up to 10 million euros or 2% of global turnover, and that's for an identified whole set of other areas in which you might have breaches. So those are maximums, those are not the fines that will be put into place, and any fine has to be effective, proportionate, and dissuasive. And that means on the one hand it's got to be painful, but proportionate means it's got to be proportionate to the misdemeanor and proportionate to the size of the organization that has transgressed. And the fines have to take into account the technical and organizational measures that have been implemented. In other words, looking at the extent of negligence. And so that leads into the question of how do you get found out? What's going to lead a supervisory authority to find out that you're in breach of the regulation? And the answer is one of 2 things. The first is that you have a data breach, and you're required to notify the supervisory authority within 72 hours of first becoming aware of a breach that you have had a breach. Within 72 hours really does mean that if the breach takes place on a Friday morning, you're going to be talking to the Information Commissioner on Monday. And that means that given most breaches take place at weekends, you need to have already worked out what your incident response and breach reporting process is going to look like, so that if you do have an issue, you can report it quickly enough. Do bear in mind that the average period it takes for UK companies to identify they've had a breach is currently running at about 114 days, and we suspect that explaining that you didn't find out for 114 days, which is why you couldn't report it within 72 hours, is not going to get an awful lot of sympathy, because it will indicate that you don't have very good processes in place to identify the fact that you've been breached. There are 2 circumstances under which you report breaches only to the data. There are 2 circumstances under which you report breaches to the Information Commission. The first is if there is a risk to rights and freedoms of data subjects, and the second is if there is a high risk. And in the second case, you also have to tell the data subjects that there's been a breach. If there's no risk, then as a data controller, you don't need to report the breach. Processors have to tell you, they have to tell you irrespective of whether there's a risk or not. If you're a controller, your data processor has to tell you there's been a breach. But if you're a data controller and you can determine there is no risk to data subjects, then you do not have to report the breach. And the simplest way of being sure that you don't have to report it is to make sure that the data is encrypted. Supervisory authorities currently recognize that encrypted laptops, encrypted drives, encryption of email means the data is protected, it's not exposed, therefore there is no risk to the rights and freedoms of data subjects. The second way you'll get into trouble is that data subjects have a right to bring a complaint to the supervisory authority. They can bring a complaint that you're not complying with the GDPR, or they can take action in a court to seek financial compensation for non-financial damages. And the either of those, reporting a breach or a data subject bringing an action, is likely to trigger an investigation, and an investigation is likely to lead sooner or later to a fine, and the fine will be based on the fact that you have been negligent, not just in the minor way that the breach led to, but in terms of your overall level of negligence. So GDPR is one of those things where you want to get compliance and maintain compliance, and you want to do what you should be doing because you don't want to have it discovered that on the third breach you're not having reported the first or second, the investigation identifies that you haven't reported them, and that could lead to a more significant sanction. GDPR comes into force on Friday. We're at the very tail end of a 2-year transition period. The law was adopted on the 8th of April 2016, adopted by the European Parliament on the 12th of April, published in the Official Union Journal on the 4th of May, and entered into force on the 24th of May, 2 years ago, and applies across all 28 member states from Friday. And the challenge, if this is genuinely the point at which you are first thinking about GDPR, is that the 25th of May is the date from which you need to be in compliance with all of the requirements of GDPR. It's not the date from which you need to start your compliance project. Technically, it's the date by which you need to be in compliance. All the data we see, however, suggests that in the UK, perhaps around about 20% of organizations will genuinely be in compliance by Friday. The significantly large numbers of organizations have still to get started on the project. One reason or another, they've only become aware of it more recently. And the Information Commissioner has said quite clearly that she's not expecting to be putting significant fines in place instantly after the 25th of May, but what she is looking for is clear evidence that organizations have recognized their accountability and have got on with, as quickly as they can, putting themselves into compliance with the GDPR. And we'll be talking about the steps that you should be taking and looking at some of the key areas of GDPR compliance. But what I'm really saying to you is the fact, if you're not yet compliant, don't panic. There are a lot of other organizations that are also not compliant, but the fact that there are many that are not compliant does not mean that you can safely delay getting on with it, because what you don't know is when you're going to suffer a data breach or you're going to have a data subject bringing an action against you, and either one of those could trigger an investigation much sooner than you're ready for it. And so the sensible thing is to get your GDPR compliance program underway as quickly as possible and to track what you're doing. So, as I said, GDPR is about the rights of data subjects, and the rights of data subjects are set out very clearly early on in GDPR. They're the rights to have information about what you're doing with their data, the rights to access it to see that you are doing what you said you would be doing, the right to rectify errors, under certain limited circumstances to have data erased if it's no longer necessary for the purpose for which it was originally collected. That's called the right to be forgotten. The right to restrict processing, the right to object to certain types of processing, and the right again, under limited circumstances, to have data given back to them in a machine-readable format so they can take it to a competitor. They also have the right to be informed if you are automating decision-making or any profiling, as well as being told of what the consequences are of that decision-making or profiling. Where you're relying on consent as a lawful basis for processing, and it's only one of a number, then the requirement is that that consent has to be on the basis of clear, intelligible information, and everything that you do to explain to customers how they can exercise their rights should be set out in transparent, intelligible, clear and plain language. So the privacy notice which you put on your website should be pretty clear, pretty straightforward, and make it evident for people as to what they do, what you're doing with their data, and what their rights are and how you're going to facilitate them. If you're relying on consent, of course, they have the right to withdraw consent at any time, and of course, as I said, they've got the right to lodge a complaint. So remember the three areas where an organization gets to be fined under the maximum possibility are rights. We looked at them briefly on the previous slide. The 6 data processing principles, which are set out here, they're listed in Article 5 of GDPR, which says that first of all, data must be processed lawfully, fairly, and in a transparent manner. Secondly, collected for specified, explicit, and legitimate purposes. And just to be clear, direct marketing is a legitimate purpose. Security of systems is a legitimate purpose. They're all good reasons for collecting data. Data must be adequate, relevant, and limited to that purpose that you identified in the second principle, kept up to date for the purposes of that purpose, retained only for as long as that purpose requires you to. And that means that you can't say, well, I collected this data in order to decide whether or not to employ somebody, decided not to employ them, but I'm keeping their data just in case. You can't keep any data just in case. It can only be kept for a specific purpose and for the purpose that you've shared with the data subject. They need to know what you're doing with their data. The sixth principle is that you have to process data in a way that will maintain information security. The seventh principle, it's not that obvious, but it is effectively the seventh principle, is that the controller, the organization that determines the means and purposes of processing the data, is responsible for and has to be able to demonstrate compliance with the requirements of Article 5. That's called the accountability principle. Organizations have to be able to demonstrate accountability. And that really means that the board itself has to run the GDPR project. You have to have a regular reports to the board. There should be ideally an accountable director, and that set of roles and responsibilities should be spread through the organization. A proper demonstration of accountability around the processing of personal data. The ICO, in fact, about 18 months ago said that this new legislation creates an onus on organizations to understand the risks to personal data and create a framework to protect that data. She said that the culture of risk prevention of privacy should pervade the organization. She talked about embedding data protection by design and by default, a change to the culture of an organization. It's not just about ticking boxes, but a change to the overall systems approach for how an organization manages data. And that means that the moment that you've got to the point where you're saying, I think we've got everything in place that we need to have, is not the end of your GDPR compliance journey. If anything, it's only the beginning, it's only the end of the beginning. You've got your basic processes in place. Now you need to make sure that it's an embedded part of how everybody inside the organization thinks about and responds to the requirements to protect the rights and freedoms of natural persons. So the principle of accountability, as I said, is about having board responsibility, board accountability, a nominated director, a corporate risk register that identifies privacy risk, having, particularly if it's a mandatory appointment, a data protection officer. If it's not mandatory, perhaps a GDPR compliance officer who deals on a day-to-day basis with compliance inside the organization. Building a privacy compliance framework, which is a combination of a PIMS, a personal information management system, and an ISMS, an information security management system. Article 30 requires you to keep records of your processing. Small organizations with under 250 employees can, under some circumstances, avoid the Article 30 compliance requirement. You need to, as I've said, have an incident response and data breach reporting process. And you should think of standards like Cyber Essentials as a minimum security requirement. Cyber Essentials is a UK government security framework which enables you to have tests carried out on the basis of 5 key controls that will eliminate somewhere up to about 80% of known low-level internet threats, which will make most small and medium organizations way more secure than they are. And an external certification of compliance to Cyber Essentials is as good a way as any of demonstrating that you took some appropriate steps to put in place necessary technical controls to protect personal data. There will be new certifications and data seals emerging. ISO 27001 is a logical framework for larger organizations, and in many supply chains is becoming a standard requirement to demonstrate that all data, as well as personal data, is properly under control. And having built a privacy compliance framework, you need then to be embedding data protection by design and by default. And that typically will start with data protection impact assessments. There are some organizations for whom a DPIA is mandatory. It's mandatory for organizations, for instance, processing large volumes of special categories of data, who are processing, who are monitoring large numbers of data subjects or processing data of large numbers of data subjects in a public space. Pretty well mandatory for those categories. Mandatory if you are creating a new process that might change the risk for data subjects, and good practice for most other organizations. The DPIA depends on having done a data flow audit. A data flow audit is a key component of a data protection record, a processing record. And a data flow audit identifies where data came from, where it gets stored, who does what with it, and helps you identify each of the security risks along each of the stages of the processing. So accountability can be demonstrated, if you like, by progress towards data protection by design and by default. Let me come back to lawfulness. I mentioned that there were a number of different lawful bases of processing. The first principle simply says that data must be processed lawfully, fairly, and transparently. The most typical basis in the UK has been consent in the past, but under GDPR, the bar for consent is very high. You can no longer rely on consent by default. So if on a website you can't say to people, if you don't want to receive emails, untick this box. If you're relying on consent, it has to be a positive step, and it has to be a fully informed positive steps. You have to have drawn their attention to and consider ensuring they've read your privacy notice, where you'll be telling them what it is that you do with their data. If you're providing consent, if consent's the lawful basis, you also have to enable them to withdraw consent and for the processing to be stopped at the point you withdraw consent. The alternatives, and from a practical point of view, think of any one of the alternatives as a better thing to do than consent. Start with processing data in order to fulfill a contract between you and the data subject. So an employment contract, for instance, you don't want to rely on consent to process employee data. You've got a contract with them, and in order to fulfill the contract, you need to know their name, their address, where they live. You need to be able to pay them, so you need their bank details, and all of that is a processing in pursuant to a contract between you. You might have legitimate interests, and for instance, if somebody buys a fridge from you, you have a legitimate interest in sending them information about the fridge and about things in relation to the fridge. You don't need consent to send them that information. Yes, you do need consent to send them information about going on an Arctic holiday, because there's no legitimate interest in sending them holiday information on the basis of their inquiry about buying a fridge. So legitimate interests, contract with a controller, statutory requirements, so you keep records because you have a statutory requirement to keep VAT records, and protection of vital interests of the data subject are some of the lawful basis that you might think of using other than consent. And many of you will be receiving emails in your email box asking you to reconsent to the processing of your personal data by somebody who has you on a mailing list. In most of those instances, it's completely unnecessary for them to be seeking reconsent because it may be they have a legitimate interest in continuing to communicate with you. Its consent is not necessarily in every instance the right thing to do. It's the default, and you should be taking very careful advice about what you do. GDPR distinguishes clearly between controllers and processors. As I've said, a controller is defined as the entity that's responsible for determining the means and purposes of processing, and a processor is the organization with whom a controller, third party, with whom a controller might choose to contract. Processors may only operate under a legally binding contract. Controllers, if they're outsourcing, must put a contract in place. If you outsource data and you don't have a contract, it's likely that both the controller and the processor will find themselves in breach of the law. So I've talked quite a lot about consent, but apart from being able to demonstrate that consent was given, you also need to recognize there are special circumstances around consent for somebody under the age of 16. GDPR provides for children under the age of 16 not to be able to consent to the processing of their data for an information society service specifically. Doesn't touch anything else, only information society services. And it provides the opportunity for member states to choose anywhere between 13 and 16 as to what that age might be. The UK has plumbed for 13. Ireland, it looks as though, is going to go for 16. And that means that you need to make sure that if you're a UK controller processing data, you need to have a method of ensuring that for people under the age of 13, where they're likely to be buying an information society service that you've established, whether they are old enough to do so. But as I said, it's only an information society service, particularly things like social media. It does not affect any of the other areas in which a young person might legally be allowed to enter into contracts. The second area which is requires special attention is what are called special categories of data. Special categories of data are, for instance, race, ethnic origin, political beliefs, health information, biometrics, genetics, and so on. And the processing of that information is prohibited under Article 9 unless you've got two elements in place. The first is a lawful basis. We've talked about lawful basis. And the second is an exception to the prohibition. And the most general exception is probably explicit consent of the data subject, but there are other alternative exceptions. They include vital interests of the data subject, statutory obligations, but you have to recognize that it's not an additional consent, it's an exception to a prohibition. And if you're going to process any elements of special categories of data, you need to have both an Article 5 lawful basis and an Article 9 exception to the prohibition. So key things to be thinking about processing, for instance, the health data of employees. Articles 12 to 18 then give more information around this area of transparency. You'll remember that the first principle again talks about processing being lawful, fair, and transparent. And in principle, in a nutshell, what GDPR is saying at this point is that communications must be concise and intelligible. You must be transparent in providing information about the purposes of the processing. Data subjects must have information about their rights. And being transparent means, for instance, that you can't bundle 5 or 6 things to which you want to consent into a single consent. That needs to be granular. Data subjects need to be able to say yes to one thing but no to another. They can't be forced to consent to processing in order to acquire something. It's invalid. If somebody has to give you data in order for a contract to be performed, don't ask for consent. And when data subjects ask to have access to their data, you no longer have 40 days to do so. You have 1 month. That's not 30 days or 28 days, it's a month, and you can no longer make a charge to the data subject. It's almost certainly going to mean an increase in the number of people asking for access to their data, and it means you need to have a solidly thought out data subject access request process and a mechanism for responding to subject access requests, making sure they're responded to in time, and making sure the data is properly redacted so that you're not releasing information that you shouldn't release, and you're only releasing it, of course, to the person whose data it really is. The other rights all need to be dealt with. You need to explain how they operate and explain to a data subject how you will help them carry out those rights. Article 25 then goes into more detail about data protection by design, and effectively is saying that data protection must be built into how you design processes or how you redesign process. And the fact that you've got a badly designed process doesn't mean you should leave it like that. You should, over a period of time, be making sure that data protection is designed into all of your business processes so it becomes part of business as usual. We've talked about data protection impact assessments. Data protection impact assessments are mandatory where there's likely to be a high risk to the rights and freedoms of data subjects. And you need to be thinking about data audits as part of your ongoing data protection by design. You should be auditing your existing data processing. You should be auditing how that changes. You should have regular reports to board or senior management on the outcome of those audits. And you need to make sure that wherever you're holding personal data, you've got a proper inventory of it, because without a proper inventory, it's difficult either to do an effective audit or to respond properly to data subject access requests. The sixth principle talks about processing data securely, and there's an intersection between the sixth principle and the Article 32, which is talking at a broader level about the security of personal data. In principle, what GDPR is saying is that personal data must be processed in a manner that ensures it is confidential, its integrity and availability are maintained. Any accidental or deliberate breach is a personal data breach and has to be reported by a processor to a controller, and if there is a risk, by a controller to a supervisory authority. Notice the definition of breach. It's any compromise. Accidental or deliberate is a breach. So data processors and controllers sensibly will be looking at ways in which you can minimize the likelihood of having to report. That means encryption. Pseudonymization is another alternative security mechanism. But you also want to make sure your systems are secure. You want to be deploying penetration testing, regular security testing, regular external controls. I've talked already about Cyber Essentials and ISO 27001. There's all ways in which you can demonstrate that you've done appropriate and sensible things to bring the protection of data, of personal data, under control. Remember, it's not going to be enough to say, well, we think we did enough. If you're going to demonstrate that you are not negligent, you're going to want to demonstrate that you took appropriate steps to satisfy yourself that you had actually done enough to secure personal data. And that all brings you back around to the privacy compliance framework, which is the combination of the PIMS and the ISMS, but it's the reflection of the data processing principles, or privacy principles they're sometimes called, those 6 principles, in your policies, procedures, controls, and records, and all of that being driven by the board's approach to governance, risk management, and compliance. So audit is a method the board would use for satisfying itself that the procedures and policies are being adhered to, that it can demonstrate the privacy principles are being complied with, and that it's meeting its compliance obligations by managing risk to the rights and freedoms of data subjects. We talked about data protection officers. DPOs are not mandatory for all organizations. They're mandatory in organizations processing substantial volumes of special categories of personal data, where organizations are processing large volumes of data in a public place, or if you're a public authority. Those entities are required to have a DPO. For everybody else, it's potentially a good practice appointment, but it's clear that if you are called a DPO, even if it's not a mandatory appointment, you will have to comply with the requirements of GDPR in respect of DPOs. And DPOs are more than people who have passed an exam. They're also people who have experience and knowledge of data protection and of compliance, of security, and all of the elements. And their role is to provide the organization with independent advice, input, and guidance on compliance with GDPR. It's clear from GDPR that somebody who has a conflict, such as a head of IT or a head of HR, can't also be a DPO, because in the formal role, you're responsible for determining the means and purposes of processing, and therefore you can't take advice from yourself. GDPR DPO has to be an independent entity, can be contracted in on the DPO as a service basis, can be shared amongst a number of organizations, but also has to have access to top management. There are many other roles inside the organization that also need to have basic training around GDPR, HR, sales, marketing, and they're all going to be dealing with personal data, so they need to have a good understanding of what GDPR requires. And that means that staff awareness training is also going to be necessary, because very quickly you realize that you're collecting personal data in most customer-facing areas. You're dealing with personal data in sales ledger and purchase ledger and in many other parts of the business. And not only is there a damaging consequence from the accidental release of personal data, but you've also got to be able to recognize a data subject access request if and when it comes in, because it no longer has to be in writing. So what role does certifications apply? And I've mentioned them a couple of times. Article 40 talks about the requirement on organizations to apply appropriate administrative and organizational and technical measures to protect the data of data subjects, but doesn't tell you what appropriate might be. And that therefore puts the onus on organizations to have a risk assessment methodology and to select controls which bring risk down to an acceptable level. Codes of conduct and certifications, ISO 27001, BS 10012, which is a standard for managing personal data, and of course technical standards like Cyber Essentials, as I've mentioned. These are all methods of demonstrating that you've taken appropriate steps to put in place relevant technical and organizational controls. The fact that you've got a certificate doesn't prove you're in compliance. It just simply means that you've done the best you can. Only a judge and ultimately the ECJ will determine what compliance looks like, because GDPR is, of course, a law. And that brings us on to international transfers. You can transfer data outside of the European Union only under certain circumstances, and that's those three key ones are if the European Commission has decided the country to which you want to transfer it has adequate data protection law, and there's only about 10 of those outside the European Union. They do not include the United States. Transfers subject to appropriate safeguards, which are called standard contract clauses, which you put in place. They're standard clauses produced by the European Union, or binding corporate rules which are relevant to international organizations or within organizations, multi-subsidiary organizations. The basic logic is that data moved outside the European Union should have all technical and legal protections that it has inside the European Union. Where the US is concerned, considering it's a fairly major trading partner and in the area of cloud services, a key service provider, and given that it's not adequate from a data protection point of view, the only thing that US companies can do is register under the EU-US Privacy Shield, which has been in place since July 2016. It replaced the previous safe harbor framework. It has a higher cost, but it is a regime which enables an organization to say that even though they're based in a insecure country, i.e. the United States, they're shielded from action because they're registered under the US Privacy Shield and are doing the things which they've committed themselves to do in order to offer a higher level of GDPR security to data subjects. And as I said at the beginning, it's the independent supervisory authorities who have the job alongside the courts of policing that. Monitor and enforce it, communicate about it, promote awareness, but also investigate, advise, and enforce. If you're operating across multiple countries, you can have a single lead controller with whom you can liaise about all of your compliance activities. That makes life simpler for multi-state controllers. It also makes life simpler for data subjects because it means that you only have to tackle an organization in one place. You don't have to try and work out which state to seek redress in. And above it all is the European Data Protection Board monitoring and ensuring correct application of the regulation, making sure there is a level playing field. And of course, given that GDPR is only effective from Friday this week, we've got many years of legal decisions and findings ahead of us, which will make clarity about specific areas of the law, which will give guidance and implementation. So for all of us starting out on the, or who have started out on the journey, you also need to be aware of what changes in the space over the years ahead as you embed data protection by design and by default. You need to make sure you're aware of what it is that you're embedding. And the ISO's final words on that were to say, of course, GDPR data protection, privacy compliance should give you a competitive edge, but if it doesn't, you know that we're not not frightened of using the big stick that we've got. We have to be clear that we're not just going to fine you for typical data breaches. We're going to come after you on the basis of the level of negligence that you demonstrate. We've been happy to levy fines. We're only able to levy fines up to £500,000 under the Data Protection Act related arrangements, but 20 million euros, well, you must expect there to be some big fines. Of course, there are not going to be big fines until people have broken the law. You can't break the law until after Friday, and then you need to be found out. There needs to be investigation. So no, don't expect there to be major fines early next week. So what do? You need to get started. If you're not compliant yet, you're not going to be compliant by the 25th of May, but you need to get started. So put your governance framework in place. Make sure the board is aware of its obligations. Make sure the board is aware of the fact it's 2 days short of 2 years late getting started on the program. Put a risk register and accountability framework in place. Decide whether or not a data protection officer is mandatory. If so, put one in place. You're probably at this point going to need to contract with a reputable DPO as a service organization. If you're otherwise simply going to have a senior GDPR compliance officer, appoint that person. Do a data inventory, work out what data you've got, who's processing data on your behalf, what data are you holding that you shouldn't be holding, what do we need to be disposing of, data that's way beyond the date on which its usefulness expired. Do a data flow audit to identify who's accessing what data. Do a gap analysis on the basis of your data flow audit. Look at the specific areas in which you have gaps between what you're doing and what the 6 data processing principles require. Certainly you want to make sure that you've got privacy notice and data subject access request processes in place as quickly as you can. If records of processing are a requirement, start making those. And then look at security analysis. Do a DPIA if that's obligatory, but certainly look at what you've got to do, protect data. Think about GDPR. The third word is protection, and make sure you are genuinely protecting data. Look at areas like cyber essentials quickly, penetration testing, all the things that you can do right now to make sure that it's difficult for a hacker to get access to your data. And then remediate all of the gaps that you found, put in place a plan to remediate with identified responsibilities and a time frame. Test your data breach response process, and then make sure you've got an ongoing process of monitoring and continually improving how you're dealing with GDPR. That's a pretty sensible 9-step approach. We've been sharing it with our consultancy clients for many months. We're helping many organizations work through on that basis. And you can access materials. There's self-help materials in the form of pocket guides, implementation manuals, documentation toolkits, compliance gap assessment tools, all of which can help you on your journey to compliance. There's a set of training courses, foundation and practitioner, which enable people to get a solid understanding of what's involved in implementing GDPR, DPIA workshop for those who have to do data protection impact assessments, and then of course a range of consultancy services you would expect from a one-stop shop, starting from gap analysis all the way through doing data flow audits, helping implement management systems, doing cyber health checks, doing penetration testing, helping with cyber essentials, and so on. So you need to get started. We'll continue providing free GDPR webinars over the months ahead. Talk to our experts about how we can help. Follow us on LinkedIn, Twitter, Facebook, wherever there's an awful lot of free information which we've made available around GDPR and related security frameworks. And ladies and gentlemen, that brings me to the end of what I was planning to say. So I'm going to turn now to questions. If you remember, what I'm going to do is I'm going to deal with the questions that people have asked, starting at the beginning. I'm going to read out questions and I'll share the answer with you. If you still have questions, stick them into the question function here. Can you give the data owner the option to opt out as opposed to opting in? No, you can't opt out, with the exception of what is called a soft opt-out, and that's otherwise known as legitimate interests to email somebody. No, you can't go with an opt-out route for general email marketing. Does there need to be a written contract between a data controller and a data processor, or something in writing, e.g. an email? It's up to you in terms of how you deal with it, but GDPR says there needs to be a contract between a controller and a processor. Typically, that will mean a legal document, and typically, if that's done electronically, that might be signed electronically, but it will be a legal document. If I retrieve contact details of French notaires from the available database of them, can I send them a newsletter as long as I give them an option to opt out? No. You can't just do that. If you're retrieving the information from a database, the first thing you have to do is send them a privacy notice or a link to an Article 14 privacy notice, which tells them where you got the data from, gives them the option to say, no, thank you, don't email me. But if you've done that, and you've done that before you first email them, then you can start sending them email as long as you give them an opt-out as you go. Yes. If a courier lost a parcel or misdelivered a parcel from a manufacturer to a customer with an invoice inside with customer name and address, I'm assuming so, there's no requirement to notify. Well, at one level, it's a data breach, isn't it? Because the data has been exposed. But the next step is to consider whether there's a risk to the rights and freedoms of data subjects. And the answer is that there is, but it's very, very minor. And so you might decide that there is no need to report it. You might be more concerned with restitution in terms of the lost package. But certainly, in technical terms, the fact that the data has been exposed means there's a data breach. You just want to be judging it in terms of risk to the data subject. Does poor data entry leading to it being sent to the wrong organization come under a data breach? Yes, it does. You sent data to the wrong person, so you breached the requirement that the data be accurate for the purposes for which it's been recorded. In a membership organization, is it permissible to contact leavers, obviously after they've left, by email to ask them what their reasons for leaving are? Well, it's permissible if you've told them that that's what you might talk to them about, for instance, an exit interview. But given that, or if you've told them when you first take them on in your privacy notice that you will, after they've left, use their email details, their private email address to collect information about why they've left. As long as they've known and you've given them due notice, then it's legal. If you haven't, then it's not. How do we action consent for those customers that we already hold data on? Seems to be a mix of understanding on this. Some emails will say they've got you down as consenting. Yeah, lots of people have bad advice. Our simple view is that if you're on an email list already, if people have been emailing you for a time, if you haven't opted out, they've almost certainly got a legitimate interest in continuing to email you, whatever the original basis was on which you joined that email list. There's nothing in GDPR which says that you have to re-consent. Yes, you might have to consent to future emails or future people joining that email list might have to consent. But the sad news is for everybody who sent out a please consent or please re-consent to us request is that they're no longer, if they suddenly decide that was a wrong move, going to be able to decide to email everybody who didn't respond, because the not responding is, hey, evidence that they don't want to be emailed. Is a signatory essential to demonstrate consent? Not necessary. What you have to be able to do is demonstrate that consent was given some active step by the data subject. It could be a signature, it could be changing browser settings, but it's something that can indicate that they've understood what they're consenting to and they actively consented. GDPR does not require you to register with the ICO, but UK law does. So there will continue to be a requirement to register, and there will continue to be a charge to pay, but that's a UK data protection requirement, not a GDPR requirement. Would you be so kind to confirm 1 month turnaround period? Yes, GDPR says you have 1 month to respond to data subject access request. It does not say 28 days or 31 days or anything else. It says 1 month. And I read 1 month as meaning that if we get a data subject access request on the 25th of May, we have to have responded to it by the 24th of May. If a company requests data in the form of a reference on one of our ex-employees, do we need to ask the subject for permission? If so, when should we ask for that permission? Should it be mentioned in the contract when we employ them? Or do we ask permission as and when it arises? Well, again, you can think about whether or not you have a legitimate interest or a statutory obligation to provide references. You almost certainly don't have a statutory obligation. It's almost certainly not in the vital interest of the data subject. So you might come down to a choice between your legitimate interests in providing a reference. You may not have a legitimate interest, and so that might bring you back to consent, in which case I would deal with that at exit interview and say to data subjects, we'd like to be able to give consent to people who seek information about information about previous employment. Do you consent to doing that? If they say no, we don't consent, say fine. You need to understand that that means that we will give no consent to anybody who writes to us. And if somebody writes to us and says, was X employed here between this date and that date, our answer will be, we are unable to say. And if you are happy with that, then no problem, go ahead. I'm sure this is one of many areas on which there will be court cases over the months and years ahead, so it's an area in which you should watch for later and better guidance. For money laundering, we will take a copy of a passport. What are the rules regarding retaining such documents for how long? Well, you need a lawful basis for processing the data. One of the lawful bases is statutory requirements. If you have a statutory requirement to collect data to carry out anti-money laundering checks, that's the data you collect. And the period of time for which you keep that information, I suspect, will be set by the Know Your Customer or anti-money laundering obligations, and that's how long you keep the data for. If all you need to do is evidence the fact that you did check the passport, but you don't need to keep a copy of it, then don't keep a copy of it. Just make a file note that says it was checked. Are IP addresses considered personal data? Yes, they are. It's a thorny subject, but specifically, it is argued that IP addresses can be used to identify a data subject either on their own or with other data, so they're therefore personal data. Personal data shared or held by the NHS is just as much a subject of GDPR as any other personal data. NHS organizations are organizations within the scope of GDPR, and NHS organizations are undoubtedly processing large volumes of special categories of data as a core activity, and so it's virtually certain that every NHS organization will require to appoint a data protection officer, will have to do data protection impact assessments, and will have to comply with GDPR. It's very difficult to see how that won't be the case. The fact that you're a national health entity does not absolve you of compliance with GDPR, not in the UK or any other member state. What would you advise to include in a privacy notice in relation to new GDPR regulations? My simplest answer to that is to say, I think we've now published our privacy notice. You can buy privacy notices off our website. Article 13 of GDPR sets out specifically what you have to have in a privacy notice. Is a list of private emails in Outlook a database? Yes. Does it contain data which enables you to identify a data subject? It's personal data. Is it in a database? Yes. Therefore, it's subject to GDPR. Yes, you need to determine how you're going to comply with GDPR in respect of that data. We're kind of coming to the end, ladies and gentlemen. A couple more questions, therefore. If some of your customers don't have email as a business, do you need to notify them of the changes you're putting in place by a formal letter? Yes. GDPR isn't restricted to electronic processing. It's a matter of you need to tell data subjects what you're doing with their data. Can employers access staff emails? That's not so much a GDPR issue as a Regulation of Investigation and Privacy Act detail. The answer is yes. Employers have a legitimate interest in monitoring employee compliance with data protection regulation and an obligation to monitor security compliance. And under certain circumstances, RIPA enables organizations to do that in any case legally. So yes is the simple answer, but you need to take legal advice to make sure you do that properly. When sending out GDPR compliance to suppliers associate, is it advised also to receive a signature to confirm they understand the guidelines and expectations you've laid out? Yeah, the requirement of GDPR is to be able to evidence that people have properly understood what you've said. A signature that people have read it is certainly potential evidence. Different organizations will manage their risk around that differently. And that, I'm afraid, ladies and gentlemen, brings us to the end of this webinar. I suspect from your questions that many of you have already started on your journey to GDPR compliance, and I hope that the questions you're asking are just enabling you to finish off the last stages. But in any case, I'd like to wish you all success on the journey. We'll continue providing support and advice to organizations on GDPR, both in terms of implementing it and in terms of supporting compliance in the years ahead. Good luck, and thank you all for being with us. Good afternoon.